Welcome back. And now let's talk about this legal battle over LGBTQ policies in schools. More than 20 Republican attorneys general sued the Biden administration on Tuesday.
Their lawsuits take aim at the USDA school meal program, which prohibits discrimination based on sexual orientation or gender identity. NBC News legal analyst Danny Cevallos joins us now to talk more about this. Danny, good to have you with us. So the Tennessee Attorney General said in a statement, quote, "This case is about a federal agency trying to change law, which is Congress's exclusive prerogative. The USDA simply does not have that authority." Can you explain what this case is actually about, how it came about, and what the Tennessee AG is arguing here?
Sure. Congress passes law. It creates statutes, but it has executive agencies that have to interpret those statutes, and they do so by rulemaking, issuing regulations. But the argument goes that when they do that, are they just interpreting federal law, or are they expanding it, in fact, creating new law? And in many ways they do. By rulemaking, rulemaking creates law because it has essentially the force of federal law. And that's not made by our elected representatives. That's made by some guy in an office at an executive branch agency. And that goes to the core of this complaint. The AGs are arguing that by interpreting Title IX, in accordance with recent Supreme Court case law, to say that it extends to LGBTQ and other protections beyond what the AGs say it does, that the executive branch agencies, the Biden administration, is exceeding its authority under the federal statute.
So can you connect this back to the meal programs now for us? What's going on there?
So basically what the Biden administration is doing is saying, hey, schools, you better comply with this federal law as we interpret it. It may not say that the law provides these protections, but that's the way we interpret it based on recent Supreme Court case law. And the AGs are saying, wait, you can't do that because it doesn't say so in the statute. That's your interpretation, and you're doing that without adhering to notice and comment provisions of the APA, the Administrative Procedures Act. You're just sort of waving your hand and saying, we believe it applies to this class of persons, therefore thou shalt fall in line, or else you might lose funding. And that's a tremendous threat for state agencies.
So let's say a Tennessee judge sided with this same group of attorneys general in a separate but a similar lawsuit, ruling states should be the ones who make these laws. What do you make of that, especially considering we know the Supreme Court did weigh in on this in 2020, basically saying in that 6-3 ruling that this title, these discriminations do extend, that they should be protected if you're LGBTQ.
Yes, and that's the key, and that's the AG's argument. That Supreme Court decision applied to Title VII. That deals with employment. And it specifically said, we're cabining this just to Title VII. So the AGs are arguing, no, now you're expanding it to Title IX, which deals with education. And not only is that impermissible, the court essentially said, we are not saying this applies to other federal law. And so that is the core. And that's why I think the AGs on this issue might have an argument.
All right. We'll keep tack on it. Danny, thank you so much. Appreciate it.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.